Malcolm X waits in a Philadelphia courthouse hallway. He's there for a hearing about a traffic citation he's contesting. A white lawyer in an expensive suit approaches, looks at Malcolm, looks at the docket sheet. Malcolm is holding, assumes Malcolm is an unrepresented defendant who doesn't know what he's doing. Offers advice nobody asked for. Says courthouse procedures are complicated. Says most people without lawyers lose their cases. Says Malcolm should just pay the fine and save himself the embarrassment. Malcolm thanks him. Then asks if the lawyer argued the motion to suppress this morning in courtroom 3. The lawyer says yes. Malcolm points out a procedural mistake the lawyer made, a mistake that could cost his client the case. But before we discover what procedural mistake Malcolm caught and how the lawyer reacted when someone without a law degree exposed his error, if you appreciate stories about how expertise gets assumed based on appearance, how people offer unsolicited advice to those they deem beneath them, how careful observation can reveal what credentials miss, please subscribe. Hit that like button if you believe competence should be judged by knowledge, not by suits and degrees. These stories matter because they show how assumptions about who knows what create blind spots in professional spaces. Now let's find out exactly what mistake Malcolm caught. Philadelphia Municipal Court. The building is on Arch Street, a gray stone structure with columns flanking the entrance, inside marble floors worn smooth by decades of foot traffic, high ceilings that make voices echo, the smell of floor wax and old wood. Courtrooms branch off from the main corridor, people everywhere. Defendants waiting for hearings, lawyers rushing between courtrooms, court officers maintaining order, the constant hum of American justice processing cases. It's Thursday morning, 9:30. Malcolm X sits on a wooden bench along the corridor wall. He's wearing a dark suit, white shirt, thin black tie, his wire-rimmed glasses. He carries a leather folder containing documents related to his case, a traffic citation. Failure to signal. Malcolm believes the officer's account is inaccurate. He signaled, the officer was too far away to see properly. Malcolm requested a hearing, plans to contest it, not because the fine is large, because the principle matters, because accepting false accusations creates a pattern of submission. Malcolm isn't a lawyer, doesn't claim to be, but he's studied legal procedure, spent time in prison law libraries during his incarceration, read case law, studied rules of evidence, learned how courts operate, not for a career, for survival, for understanding the system that controls Black lives, for knowing how to navigate institutional power. The corridor is busy this morning. 20 or 30 people waiting. Some sit on benches, reading newspapers. Some pace nervously. Some talk quietly with their lawyers. Malcolm sits alone, reviewing his notes, going over the questions he plans to ask the officer, the arguments he'll make. He's prepared. Calm, ready. A white lawyer walks past, mid-40s, gray suit, expensive, tailored, Italian leather briefcase. Gold watch. The appearance of success. His name is Richard Donovan, partner at a mid-size Philadelphia firm, criminal defense. Been practicing for 18 years, handled hundreds of cases, knows municipal court procedures inside and out, or thinks he does. Donovan walks past Malcolm, glances at him, sees a black man in a suit sitting alone holding papers, makes immediate assumptions. Defendant, no lawyer. Probably doesn't understand what he's facing. Probably going to embarrass himself. Donovan has seen it hundreds of times, people representing themselves, making procedural errors, losing cases they might have won with proper representation. Donovan stops, turns back, approaches Malcolm. His expression is what he probably thinks is friendly, but comes across as patronizing. The look of someone about to offer help to someone they consider less knowledgeable. He asks if Malcolm has a lawyer. Malcolm looks up, says no. He's representing himself. Donovan nods. Expected answer. He says that's usually not a good idea. Says courthouse procedures are complicated. Says judges expect certain formalities. Says people without legal training usually make mistakes. Says most people without lawyers lose their cases. Malcolm listens politely. Doesn't interrupt. Doesn't show offense. Just listens to unsolicited advice being delivered, as if it's helpful wisdom. Donovan continues. Says Malcolm should consider just paying the fine, save himself time and embarrassment. Fighting a traffic ticket without a lawyer rarely works. The system is set up for lawyers. Judges have little patience for self-represented defendants who don't follow proper procedure. Malcolm will probably lose and waste a day in court. Malcolm thanks him, says he appreciates the concern. His tone is genuine. No sarcasm, no hostility, just polite acknowledgement of someone who thinks they're being helpful. Then Malcolm asks a question. Asks if Donovan argued a motion to suppress this morning in courtroom 3. Donovan is surprised by the question. How does Malcolm know about his case? He says yes. He did argue a motion to suppress. Why? Malcolm says he observed the hearing, was waiting for his own case. Sat in the back of courtroom 3. Watched Donovan argue that physical evidence should be suppressed because the search was unconstitutional. Donovan's client is charged with possession. The evidence was found during a vehicle search. Donovan argued the stop was pretextual, that the officer lacked reasonable suspicion. Donovan's expression changes. Confusion. This black man without a lawyer not only attended his hearing but followed the legal arguments. That's unexpected, but Donovan's still confident. Still assumes Malcolm didn't really understand what he was watching, just heard words without grasping the legal complexity. Malcolm continues. Says Donovan made a strong argument about the pretextual stop, but says Donovan didn't properly preserve the issue for appeal. Says when the judge asked whether Donovan was challenging the stop under the Fourth Amendment or under Pennsylvania state law, Donovan gave an ambiguous answer. Said both. But Pennsylvania procedure requires specific objection grounds. By arguing both without clarifying which was primary, Donovan may have waived the federal constitutional claim. Donovan's face changes completely. The patronizing confidence evaporates, replaced by concern. Malcolm is right. During the hearing, Judge Harris asked that exact question. Donovan, rushing through his argument, said he was challenging the stop under both federal and state constitutional grounds. Thought he was being thorough, but Pennsylvania appellate courts require preservation of specific objections. If the trial court ruling can be upheld on state law grounds, appellate courts won't reach federal constitutional questions. By failing to clearly prioritize the federal claim, Donovan may have eliminated his client's ability to appeal to federal court. Donovan asks how Malcolm knows Pennsylvania appellate procedure. Malcolm says he studied it, read Pennsylvania case law, understands the preservation requirements. Donovan is stunned. This isn't casual knowledge. This is specific procedural expertise. Malcolm continues. Says there's another issue. When the prosecutor introduced the lab report analyzing the substance found in the car, Donovan objected on hearsay grounds. The judge overruled the objection, but Donovan didn't make a proper foundation objection first. Didn't challenge whether the lab report met business records exception requirements. Didn't ask about chain of custody. Just jumped to hearsay. By failing to object to foundation first, Donovan may have waived that issue too. Donovan is no longer thinking about Malcolm's traffic citation. He's thinking about his own case, about his client, about the procedural errors Malcolm just identified, errors that could cost his client the case, could prevent a successful appeal, even if the search was unconstitutional. He asks Malcolm where he learned this. Malcolm says he studied in prison, read law books, studied appellate decisions, learned how appeals work, what issues need to be preserved, how procedural defaults happen. Donovan asks what Malcolm was in prison for. Malcolm says burglary. Served 6 years. Used that time to educate himself, to understand the system that incarcerated him. Donovan is quiet for a moment. Processing. He came over to condescend to an unrepresented defendant to offer patronizing advice about not embarrassing himself, and that defendant just identified serious procedural errors in Donovan's own case. Errors Donovan didn't catch, errors that could have devastating consequences. He asks if Malcolm is sure about the preservation issue. Malcolm says yes, Cetesson, Pennsylvania case law. Commonwealth v. Edmonds says Pennsylvania Supreme Court requires clear articulation of whether constitutional claims are based on federal or state grounds. When there's ambiguity, Appellate courts will assume state law grounds, says Donovan's answer to Judge Harris, was ambiguous. Creates risk. Donovan knows Edmonds. It's a foundational case. Malcolm is absolutely right. Donovan made an error. Not a huge error in the hearing itself, but a potentially significant error for appeal, an error a criminal defense lawyer with 18 years' experience shouldn't make. Donovan asks about the foundation objection. Malcolm says the lab report was introduced through the arresting officer's testimony. The officer testified about what the lab report said, but the officer didn't lay foundation for the business records exception, didn't testify about lab procedures, record-keeping practices, reliability. Donovan's hearsay objection was correct, but incomplete. He should have objected to foundation first, made the prosecutor establish that the document meets the business records exception before reaching the hearsay question. Again, Malcolm is right. Donovan knows the evidence rules, but in the moment, focused on the bigger issue of whether the search was valid, he didn't make the complete objection, took a shortcut. That shortcut could matter on appeal. Donovan sits down on the bench next to Malcolm. Not because he wants to, because his legs feel weak, because he's realizing his client might lose an appeal because of procedural errors, because someone he assumed was ignorant just demonstrated superior knowledge. He asks Malcolm what he should do. Can these errors be fixed? Is there a way to preserve the issues properly? Malcolm says Donovan should file a motion for reconsideration, should clarify that his primary objection was federal constitutional, should preserve that issue explicitly, should cite the specific Fourth Amendment grounds, says he should also file a supplemental brief on the foundation issue, point out that the business records exception wasn't properly established, give the judge an opportunity to reconsider before the record is closed. Donovan asks if that will work. If judges typically grant reconsideration on procedural grounds. Malcolm says maybe, says judges don't like admitting error, but if Donovan frames it as clarification rather than correction, if he provides strong case law showing why the preservation matters, if he emphasizes protecting his client's appellate rights, the judge might reconsider. Says it's worth trying. Better than letting the errors stand and hoping appellate courts overlook them. Donovan asks how Malcolm learned all this. How someone without law school knows appellate preservation doctrine better than practicing lawyers. Malcolm explains his prison education, 6 years in Charlestown State Prison in Massachusetts. Spent that time in the library. Read everything available on law, constitutional law, criminal procedure, evidence rules, appellate practice. Copied cases by hand, studied how courts reason, learned what separates winning appeals from losing ones. Says prison gave him time most people never have, time to actually study, rather than just pass exams. Donovan is quiet, processing this. He went to law school, passed the bar, built a practice, makes good money, has status and respect, but his education was rushed. 3 years of cramming, bar prep courses, memorizing rules for tests. He learned enough to practice but never deeply studied the way Malcolm describes, never had months to just read cases and understand reasoning. His education was about credentials. Malcolm's was about knowledge. Donovan thanks Malcolm, sincerely, not patronizing anymore, actually grateful. He stands. Needs to go to his office. Needs to research the cases Malcolm cited. Needs to draft those motions. Needs to try to fix the errors before they become permanent. He apologizes to Malcolm, says he made assumptions, says he was wrong, says he thought he was helping but was actually being condescending. Malcolm says it's fine, says people make assumptions all the time, says what matters is whether Donovan learns from it, whether he'll think differently next time he sees someone without a lawyer, whether he'll remember that credentials don't equal knowledge. That study can happen anywhere, that some people know more than their circumstances suggest. Donovan walks away, back down the corridor, toward the exit, his confidence shaken, his certainty about who knows what disrupted. He came to court thinking he was competent, skilled, experienced, and a self-represented defendant with a traffic citation showed him errors he missed. Malcolm returns to reviewing his own documents. His hearing is scheduled for 10:30. Still has an hour to wait. He thinks about the interaction, about how Donovan assumed ignorance based on appearance, based on the fact that Malcolm was sitting alone without a lawyer, based on stereotypes about who possesses legal knowledge. This happens constantly. Lawyers assume defendants don't understand procedure. Judges assume unrepresented litigants are incompetent. The system is designed for credentialed experts. People without law degrees are expected to fail, expected to make mistakes, expected to need professional help. But Malcolm actually studied, not for credentials, for knowledge, for understanding, for the ability to navigate a system designed to exclude people like him, and that study, that knowledge, is real, is legitimate. Regardless of whether he has a law degree, at 10:30, Malcolm's case is called. He walks into courtroom 5. The judge is Michael Santos, late 50s, been on the bench for 12 years, sees hundreds of traffic cases every month. Most people plead guilty, pay the fine, move on. Few people contest, fewer win. Malcolm approaches the defendant's table. The prosecutor, a young assistant city solicitor, sits at the other table. The officer who issued the citation sits in the witness gallery. The judge looks at Malcolm, asks if he has representation. Malcolm says, no, he's representing himself. The judge's expression suggests this will be quick. Self-represented defendants rarely win. The prosecutor presents the case, calls the officer. The officer testifies he observed Malcolm's vehicle change lanes without signaling, says he activated his lights, says Malcolm pulled over, says Malcolm was polite but the violation was clear. Malcolm cross-examines, asks about the officer's position when the alleged violation occurred. The officer says he was approximately 150 feet behind Malcolm's vehicle. Malcolm asks about the angle. The officer says he was directly behind. Malcolm asks if other vehicles were between them. The officer hesitates, says yes, 2 vehicles. Malcolm asks how the officer could see Malcolm's turn signal from 150 feet behind through 2 other vehicles. The officer says he had a clear view. Malcolm asks if the officer's dash camera recorded the incident. The officer says yes. Malcolm asks if the prosecutor has the video. The prosecutor says no, didn't request it. Malcolm makes a motion, requests continuance to obtain the dash camera video, says it's material evidence. The prosecutor objects, says it's unnecessary, says the officer's testimony is sufficient. Judge Santos looks at Malcolm, asks if Malcolm is familiar with discovery procedure. Malcolm says yes, says Pennsylvania Rules of Criminal Procedure, Rule 573, allows defendants to request material evidence, says dash camera video of a traffic stop is clearly material, says he's entitled to review it before proceeding. The judge is surprised. Malcolm cited the correct rule, knows the procedural requirements. This is not a typical self-represented defendant. The judge grants the continuance, says the prosecutor should obtain the video, says they'll reconvene in 2 weeks. Malcolm thanks the judge, leaves the courtroom. The prosecutor is annoyed. Expected quick guilty plea, got a knowledgeable defendant who knows procedure, who made a proper motion, who forced continuance. 2 weeks later, Malcolm returns. The video has been obtained, viewed by both sides. The video shows Malcolm did signal. The signal is visible. The officer was wrong. The prosecutor dismisses the case. Malcolm wins. Donovan never sees Malcolm again, but he remembers him. Remembers the man who exposed his procedural errors. Remembers feeling embarrassed and grateful simultaneously. Remembers learning that expertise exists outside credentialed spaces. Donovan becomes more careful, more thorough, more aware of procedural preservation, makes sure his objections are clear, makes sure foundation is established before arguing hearsay. The errors Malcolm identified never happen again. Malcolm unknowingly made Donovan a better lawyer. Years later, Donovan tells the story to younger associates, tells them about the time a self-represented defendant taught him appellate procedure, uses it as a lesson. Don't assume ignorance. Don't assume lack of credentials means lack of knowledge. Some people study harder than law school ever required. Some people understand procedure better than lawyers who've been practicing for years. If this story made you think about how credentials create assumptions about competence, how unsolicited advice reveals more about the giver than the receiver, how study and knowledge exist independently of institutional validation, subscribe. Hit that like button if you believe expertise should be judged by what people know, not by the degrees they hold. Consider who you've dismissed because they lacked credentials. Consider what knowledge you've missed because you assumed ignorance. Consider how many people study harder than those who get the degrees.